Hi, good evening. It's a Supreme Court judgment under the Consumer Protection Act. Citation is Ansel Crown Heights Flat Buyers Association versus Ansel Crown Infra Build Private Limited. Interesting issue. The question before the Supreme Court was, can persons who are respondents in the execution proceedings against whom no notice or complaint was filed under the Consumer Protection Act, can they be brought within the net of execution on the premise that they were directors or promoters of the judgment debtor, that is a company? The facts of this case: association, the Ansel Crown Heights Flat Buyers Association, I will hereafter call them as association, they filed a consumer complaint against Ansel Crown Infra Build Private Limited, hereafter ACIPL. So individual agreements were there. ACIPL agreed to hand over the flats within 36 months. So from the date of execution of agreement, ACIPL failed to execute, failed to construct the houses within the time frame. So failed in their commitment. So the association instituted consumer complaint before NCDRC. The association made the ACIPL as one of the respondent, and the second, third, four respondents were directors and promoters. NCDRC, while admitting the complaint, it said in its order, no, the complaint will proceed only against the ACIPL. That is a company who is the builder. And it will not proceed against the directors or promoters. I don't know what are the reasons, because it is not recorded in the Supreme Court judgment. So, but they said you remove the directors and promoters. Subsequently, in compliance with the order of the NCDRC, the association removed the names of the directors and promoters from the respondents and then filed a amended complaint. Then matter went on, final hearing happened. The complaint filed by the association was allowed by NCDRC. The NCDRC directed ACIPL to complete the project and hand over possession within a particular time frame, or if buyers were not interested in taking possession, then ACIPL was directed to refund the amount along with interest. ACIPL did not comply with the order of the NCDRC. So the buyers initiated execution proceedings against ACIPL. In the meantime, insolvency proceedings were initiated against ACIPL. NCLT passed an order of moratorium. Then the opposite counsel must have, ACIPL counsel must have filed that moratorium order before the NCDRC. NCDRC adjourned the case sine die, that is indefinitely. This was challenged by the association before the Supreme Court, saying that moratorium applies only against the company, that is ACIPL, and not against the directors or promoters. So execution proceedings against the director and promotion must be allowed. Supreme Court agreed, but it said we are keeping all the pleas open to the directors and promoters to contest the execution proceedings. NCDRC heard the case, finally dismissed the execution proceedings, execution petition filed against the director or promoters, as the order of the NCDRC was passed only against ACIPL. Then this was again challenged by the association before the Supreme Court. The question before the Supreme Court, already I said, was that can persons who are respondents in the execution proceedings, that is the directors or promoters, against whom no notice was issued under the complaint filed before the NCDRC, can they be brought within the net of execution on the premise that they were directors or promoters of the ACIPL? So the directors or promoters who were arrayed as respondents, Supreme Court noted this. The directors or promoters who were arrayed as respondents were removed from the complaint by the order of NCDRC. This was not challenged by the complaints because that order was not challenged. It was accepted by the complainants. Hence, that order has become final. On that basis, the consumer complaint proceeded only against ACIPL and not against the directors or promoters. Supreme Court said no pleadings were directed to be filed against, nor issues framed in relation to the directors or promoters, and no findings came to be recorded against them at any stage of the adjudicatory process. Notice, hearing, whatever it is. The adjudication process is from the notice to passing of the order. Once the list stood consciously and finally confined to ACIPL, the adjudication culminated in an order binding exclusively ACIPL and none else. The order of the NCDRC neither records any determination of liability against the directors or promoters, nor contains any direction requiring them to perform or refrain from performing any act. In the absence of pleadings, adjudication, or findings against them, the essential foundation for fastening liability upon the directors or promoters is plainly lacking. It is not there. Supreme Court said, since the judgment and order had not been passed against the directors or promoters, at the stage of execution, the order passed by NCDRC against ACIPL could not be enforced against them. It is settled law that execution must strictly conform to the decree. That is the decree passed by the judgment passed by NCDRC against ACIPL. It is straight law that a decree cannot, by a process of execution, be employed to shift or enlarge the liability so as to bind the persons who are neither parties to the decree nor otherwise legally liable thereunder. Where the judgment debtor is a company, the liability of its shareholders or joint venture partners remains confined to the extent of their shareholding or to such guarantees or undertakings as may have been expressly furnished by them. So it is limited liability. Whatever is the share value or whatever is that liability which is limited by them, that alone is payable by them. Not the you cannot say the entire amount has to be recovered from the director or promoters. In the present case, association neither pleaded nor established that the directors or promoters have given any guarantee or surety in respect of the investments made in the project. Execution proceedings cannot be initiated against directors or promoters who are neither judgment debtors nor guarantors and against whom no independent liability under the order allowing complaints is established. Consumer Protection Act envisages a complete adjudicatory process. These are not procedural formalities, but substantive safeguards that precede the fastening of liability. No adjudicatory process was undertaken against the directors or promoters, already we have seen. Supreme Court also said the doctrine of invocation of piercing the corporate veil is unwarranted in this case. It is an exceptional measure to be resorted to only upon a clear finding that the corporate personality was abused for fraudulent or dishonest purposes. No such fraud or misuse was established in this case. In the absence of that, directors or promoters cannot be exposed to personal liability through execution. So Supreme Court said the order of the NCDRC is correct, which dismissed the execution proceedings against the directors or promoters. My comments, even though I am a small fellow, even though we cannot dispute the order of the Supreme Court, which is correct, because they were not complainants before they were not opposite parties before the directors or promoters were not opposite parties in the complaint. At that time, the flat buyers would have simply complied with the order of NCDRC in deleting the directors for promoters in compliance to the order of the NCDRC. They must have complied with the order not to irritate the members or invite the anger of the members. Sometimes I have seen many judges get agitated when you say something which is not, uh, which is against what they are saying, because their mind gets locked, so they get agitated. So if you are not doing it, then they will say, okay, we will see. That tone itself immediately will threaten the members, the association people, the flat buyers. But at that time, they would not have expected this twist in the end. So that is one. Two. Now with the order of NCDRC, even though it is in their favor, in the favor of the association or flat buyers, what the flat buyers will do in the absence of any money in the accounts of ACIPL, I am not sure. So it will lie as a mere order because ACIPL refuses to do anything. It is a case of winning the war and losing the territory. Then I am not sure why NCDRC asked the complainant to delete the directors or promoters from the complaint. Why? What is the reason? What right NCDRC has got to direct the complainant to delete the directors or promoters of the same company? Who is the sufferer? Who should be respondent? Who should decide? It is not the director or promoter of some other company, third party company has been arrayed as respondent. It is the company's own director or promoter. The maximum, in my view, in my humble view, the maximum view is NCDRC at the time of passing the final order could have said, no, no, you have not produced any proof or any evidence or pleading. That fastens a liability on the director or promoter. Hence, your complaint against the director fails. That they could have said. And then the parties could have taken it before the Supreme Court. But NCDRC at the initial stage itself said, no, no, you remove the directors or promoters. These people, uh, even I can't say this, but how the flat buyers who are already suffering, they would have thought, okay, we will remove as per the order of the, because the court is saying we will remove. They would have removed it. Uh, hope finally, what I am saying is, hope the courts are aware of the fees to be paid to advocates and advocate on record in case of filing of SLP. Because in these case of orders, in these types of orders, you have to go to Supreme Court. If you have to go to Supreme Court, there is one advocate on record, local advocate, and you need one senior lawyer or everything. Builder's case, 130 people are there, then you know the fees. So will the Supreme Court know or the NCDRC know the fees to be paid to the advocates, even though I am an advocate? So that also should be taken into account. Finally, can an honest litigant suffer due to erroneous order of the court? Because what is the mistake of the litigant? Court asked him to remove, he removed it. So unfortunate. I do agree. They could have challenged it, but considering the costs involved or everything involved, they must have thought at that time, okay, we'll remove it. What is there anyway? ACIPL is there. So can an honest litigant suffer due to erroneous order of the court? That is the point which I want to raise. Thank you very much. Have a great evening. Bye.